Well, thank you for joining us this evening then for the inside track on SQE2 prep with Acuity Law. Um, I've enabled closed captions and the slides and a copy of the recordings will be sent out hopefully to everyone tomorrow as well. I've got some prepared slides to run through just with some kind of key facts about the SQE2 assessments and SQE2 prep. But the main aim for the session is really to allow for our former students, Sophie and Courtney, to share their experiences of preparing for and sitting the SQE2 assessments. Thank you for those who have submitted questions when you registered as well. I've made a note of those and sort of collated them together. But any further questions that you think of throughout the session, please do add them into the chat and we'll try and answer those as well. If it's anything that's slightly outside of the remit of this webinar session, I can come back to you tomorrow and clarify those for you as well. So just some introductions then. So I'm Nicola Gorge. I am the Student Recruitment Manager at the College of Legal Practice. If you have any inquiries, any concerns or questions about studying with us, then it will be myself or a member of my team that will assist you with those if you email or if you call us. We're here to sort of help support people making their decisions about studying. Sophie, would you like to introduce yourself, please, as well?
So I'm a solicitor in the commercial property team here at Acuity. I did the back scheme in 2022. Around this time, we currently have our back schemers with us this summer, so it's nice, but it's also scary to look back and think that was me 3 years ago. So qualified in February, did SQE1 in July, and sat SQE2 the following year. So that was July 2023 and 2024.
Brilliant. And then Courtney, is it as well?
Yeah, so I qualified into the commercial litigation team at Acuity in September last year. So I didn't do the vacation scheme at Acuity, but I started my prep course in the August of 2022 before starting my training contract qualifying work experience at the end of September. I sat my SQE1 exams in the January of 2023 and then did my SQE2 exams the following year. So similar timeline.
Brilliant. Okay, thank you so much, and we'll come to you shortly to obviously find out much more details as well about your experiences. So just to give a brief overview for those who are not aware of us. So the College of Legal Practice, we are fully online postgraduate law school. We're built for delivering online and we specialise in SQE preparation. Our parent company, the College of Law, are leaders in legal education in Australia, and so we are very experienced in delivering digital learning. We're all about accessible and affordable legal education. Traditionally, the legal profession has had many barriers to entry, so we do our bit to eliminate that by offering courses at an affordable price. We provide personal and targeted individual support where students get access to high levels of one-to-one tutor supervision. And lastly, we ensure we facilitate an inclusive learning environment. We can make reasonable adjustments for those that need it as well to give everyone the opportunity to get the most out of their learning. There's a number of logos on the screen there from firms that we partner with, obviously such as Acuity Law. We also work with some universities as well to provide the SQE elements of their master's programs as well. So I'm just going to give some brief facts then as well about what the actual SQE2 assessments are, because I know from some of the questions coming through, there were some people that weren't really too familiar at all. So the SQE2 assessments then, these are focused on the legal skills. So you'll be tested on oral and written legal skills, and there's 6 skills in 5 practice areas. So the practice areas are business, dispute resolution, property, criminal, and wills. And then those legal skills listed there as well: advocacy, case and matter analysis, client interview and attendance note and legal analysis, and then legal drafting, research and writing. And the way that it's structured, there's actually 16 skill assessments that they call stations, 12 of them are written and 4 are oral, but we'll be hearing much more about those from Sophie and Courtney shortly as well. You can sit for the written assessment worldwide at Pearson test centres, but currently the oral assessment can only be set in those 4 locations of Cardiff, Manchester, London and Birmingham. So things to think about there in terms of when you're arranging taking those assessments. Currently, assessment dates are 4 times a year for the SQE2, so January, April, July and then October. And the fees for the SQE2 assessments that you book through the SRA is currently £2,974. And then just to give you an overview, so it makes a bit more sense as well, when Sophie and Courtney are talking about how they studied with us. So our preparation course is delivered over full-time or part-time options. It's delivered fully online. And then there are live sessions over Zoom, which are like seminar sessions with supervisor solicitors. There's also over 100 different activities, including skill practice and simulated assessments, 16 timed SQE2 skill practices with individual written feedback as well as group feedback sessions, and then the 3 timed final assessments and revision activities. As well as the information through the online learning platform, you also get access to hard copy skills guide provided to you as well. And there's also access to our SQE1 prep materials. I know there were some questions coming through from people who hadn't sat SQE1 and actually had an exemption for it because they studied LPC instead. So that would obviously be quite beneficial for those. And then alongside all of that as well, you also have your supervision sessions and an SQE readiness review with your supervisor as well. The QR code there is for to access a demo of the SQE2 preparation course. I will also put a link into that onto the email that I send out tomorrow as well, though. And then I'm just going to run over briefly the next sort of set of dates that we have for our SQE2 preparation course for those that are interested as well. So our prep course costs £2,700. And as I mentioned, we offer it currently on a 10-week, 20-week or a 40-week basis. So you'll see there's different time frames of actual study to go with that as well. So the 10-week one is very much full-time, where we would suggest around 30 to 35 hours of study time per week. And then the 20-week one is probably more like 15 to 20. And the 40-week one is more like 8 to 10. So it's all the same, exactly the same content. It's just spread out over that longer period of time, really. So what I will do then is take us straight through to have a chat to Sophie and Courtney now, and I will stop sharing my screen. Lovely. So now that we've kind of given everyone just a brief overview, could you both talk us through your kind of experience of the exam format and on those days that you went for the exams? Obviously, they're over different days as well. So I don't know who wants to go first, but if you want to just explain about, you know, what they were like when you took each one. You know, was it the next day, things like that?
So the way I sat mine was on the Thursday, I had 2 oral exams, and on the Friday I had 2 oral exams. I'm not sure if the SRA is still doing it in this way, but online they did have what was on those 2 dates. There is a bit of a line underneath to say we can't guarantee, but it was correct for me. So on the first day, I did my dispute resolution and my wills client interview, and the next day then I think was the criminal litigation, criminal advocacy, followed by the property. Then the following week I had 4 exams on the Monday, 4 exams on the Tuesday and 4 exams on the Wednesday. Similarly, if you look online, there is some guidance from the SRA. It tells you what dates you do everything. Just a bit of a tip, for business, you don't have any oral exams. You just have all 4 of the written tests on business, whereas on the other 2 days, you'll have 2 which are for, say, dispute resolution, and then 2 which are for property. But the reason the 4 are for business is because you obviously don't have that oral exam for business. So what I would recommend anyone does is check on the SRA sort of guidance first to make sure you fully understand sort of what exams will be on what day and what topics you're going to be quizzed on, because that was probably something I looked into a little bit too late, and it would have saved me maybe quite a bit of worry thinking, oh gosh, what's the business oral going to be when there isn't a business oral.
Was yours sort of quite similar to that, Courtney?
So I did my written ones first, so I did my oral one second. So I had the same format as in Monday, Tuesday, Wednesday of the 4 exams on each date. And I think in that regard, with what Sophie was saying about the different practice areas being on the different dates, that obviously you know what practice area, or following the SRA guidance, you can see what practice area is going to be on each day, but you obviously don't know which skills they're going to be assessed of. So you've obviously got the legal drafting, legal research, legal writing, and then your case and matter analysis. But you don't know, you could have one on dispute res, legal drafting, and legal writing, or you could end up with it the other way around. So in that respect, I think it is useful to check, but don't assume that because dispute res is first, the first 2 skill sets will be applicable to that practice area. But I think it is definitely useful because, like you say, for business that you're going to have to do a written exam in respect of that whole unit. There's no option. You have to do each of the skill sets for that topic. Then I had my oral exams the following week. So a spread of I think it was a Monday and the Thursday I had mine on, so a slight break in between. But yeah, I think the oral assessments themselves, I think that's something that you can't really prepare yourself for until you're there, because
well, I was going to ask that because I think it's it's quite a difficult one to kind of picture, isn't it, for people? So yeah, could you explain, Courtney, about how was it? What were they like then?
So obviously I did mine in Cardiff, so this, like, my experience, obviously I don't know if it's exactly the same in other Pearson test centres, but essentially you go in, mine was in a hotel. So you have like a smaller group. So I think there was about 6 of us in our group. And then you stay with that group for each of the days. So essentially you're all taken to one room. You're not meant to discuss anything to do with the exams, which is obviously quite difficult when that's the only reason that you're there. But it's quite nice to hear about other people's experiences. And then essentially you're moved so when you do advocacy, you're escorted up to, it's in a hotel room. So it's a bit strange in a way, isn't it? Because you walk in and so you essentially stand outside the doors, don't you? And you knock and then enter, and then from the moment you go in, you're acting in the role that you're in. So if it's a client interview, you're acting as the solicitor interviewing a client. If it's your advocacy submission, you're doing the representations to the judge. And then afterwards, you're escorted back to the room. So it does seem quite formal, but obviously they have to do that because there's multiple groups moving around the test centres. But I think it helps the fact that when you go into the room, immediately you're in the scenario. It's not like you walk in, you have to say a candidate number or anything like that. It helps you go in and be in that mindset straight away. It's exactly the same.
Yeah, exactly the same. And just to add, when you have a break, so you have your say now advocacy in the morning, and then a bit later you'll have your client interview, there is a little break in between and you're not allowed to look at notes. So you just have to sit in your little group. It's actually quite nice because it gives you a bit of a chance to just breathe before you go into the next one. One thing I will say about the oral exams is I think people get really anxious about them because oral exams aren't actually that common anymore. I think especially after COVID and during COVID. But it's actually a really nice opportunity to show what you know. And because it's an oral exam, even if you're not entirely sure about one point, you'll have other bits of information that you can show off your skills in that way. There's also loads of easy marks to pick up. So, when you're doing your advocacy, make sure you know how to call the judge, what level the judge is at, because that will determine what you call them, what you refer to them as. Make sure there's really good guidance on the College of Legal Practice preparation, how to start, how to split it up, how to conclude, because obviously because of the split is half your legal knowledge and half how you sort of present that information is how SQE2 is marked. You're picking up so many skills and picking up so many marks on that soft skill that even if you falter a little bit on the law, you can boost your grade with those like practice skills. So make sure you go into it. It's really hard to say, but being confident. And from my experience, the examiners were really nice. And that gives you a bit of a boost as well. But if you go in sort of confident and being like, I know what I'm doing, I know what I'm saying, that also, I think, often will give you quite a few more marks because you're coming across as if you're ready to be a solicitor, which is essentially what they are looking for.
Yeah, I was going to say, I feel like that's part of it, is that, it's basically role playing, isn't it? Exactly what you're going to be doing as a solicitor. So as Sophie said, if you come across like you know what you're saying, obviously don't give negligent advice, but as long as you're coming across in a way that shows that you're confident, even if, like you were saying, the legal knowledge is slightly not there, just be confident in your basic things like how you speak to clients, just general mannerisms and professionalism. I think that goes a long way.
Yeah, definitely. And in practice, there will be times clients will ask us something and we have to say, oh, I'm not entirely sure on that point. Let me double check and come back to you. I'll follow up. And then, at the end of the meeting, you'll say, oh, and I'll check that point and I'll follow up in an email with you. And don't be afraid to do that, because that's what they also want to see. They want to see if you don't know, you're not just going to start making up information because that's negligent. It's perfectly okay to say to a client, oh, I'm not entirely sure on that point. Let me come back to you.
Yeah, that's really interesting to hear your experiences of it actually. So in terms of preparing for it then, and obviously studying for the preparation course, as we know, you both working at Acuity. Did you both study over the same period of time? Was it both the 20-week or the 40-week or the?
I did a 20-week.
Yeah, I did 20-week.
Yeah, and was you working at the same time in your role, or did you focus just on studies?
Yeah, so we were both working full time. So at Acuity, you get a day and a half a month. So you can either take that on a per month basis. So while you're doing the prep course, say it's 20 weeks, you can take a day and a half each month that falls within that. Or they've recently updated the policy based on feedback that you can accrue your study leave. So obviously, some people might really like that. I mean, I did that because I was like, I'd rather have some time before the exam just to really get my head into it. Whereas some people would, rather stay on top of it if they've got other commitments, maybe where in the months they then might find it difficult to find that dedicated time. Because I think it does help, doesn't it? But yeah, so I think the 20-week course, obviously, like you're saying, it's about 15 to 20 hours a week. I think it's quite hard because I think you say to people, it seems like a lot, and at the time, it's just being very disciplined with the balance, because you don't want to burn yourself out of working a long time. I think lots of people know that law doesn't necessarily have the most sociable hours, but I think it's like then being disciplined with your time around that, and there might have to be some sacrifice that you make, but I think ultimately that is worth it, because what you get in, you will get out. And I think that's just something to be aware of, isn't it? Like when you're deciding which course length to do, just to be mindful that obviously if you go for a 20-week, you are going to have to maybe sacrifice a few more things.
Yeah, I think there's a variety here of people who have chosen the 20-week and the 40-week, and I think that makes sense because it's a really personal decision. And I think you should try and I think students should not put any pressure on themselves to choose one or the other. I think the best thing you can do is sit down, whether you draw up a table of the pros and cons, or whether you sit down and write, what have I got coming up in the next year? If you've got a job and you know that there's a really busy period coming up, then maybe the 40-week course is going to be better. At the end of the day, it's the difference of 20 weeks. It's not the end of the world. So it's a really important decision, and one that people shouldn't neglect if which one they're considering. And also reach out. We've both got experience doing the 20-week course, and we would probably stick to that if we did it again. But if you know someone who did the 40-week, reach out to them and sort of ask them what was good and what wasn't good about it. And then based off people's feedback, that can help you make the decision as well.
Yeah, definitely. I think you're exactly right in terms of saying really is personal. If you've got a lot of caring responsibilities, for example, as well, you probably find that you have less of an evening than others might as well. And what was kind of the intensity of SQE2 prep like in comparison to like SQE1 prep as well? Did you feel like you were putting in kind of the same amount of hours, or how did it feel that way?
I probably would say for me it was less hours throughout the course, just because, and I think this is where being in practice is so helpful. A lot of the written exams, especially, you've picked up a lot of those skills. How to professionally write an email or a letter, how to build up a case, how to research. So I found that the skills were a bit easier. And obviously, there's a few less topics in SQE2 than there are in SQE1. There's no legal systems or services. So a bit less content. And obviously, I was quite fortunate that I got to do SQE2 quite quickly after SQE1. So a lot of the knowledge was still there. But I don't know how.
Yeah, I think it's easier with SQ1 obviously because it's single best answer with the multiple choice questions. It's quite easy to dip in and out of doing questions. You can just pick up 10 questions here and there.
Yeah.
Whereas obviously with SQE2, I think it is really important to, within like a time set environment and acting as if you're in the actual exam with the oral exams, the advocacy submissions and the client interviews, to do that on a real time basis, because I think in that respect, it feels like you're doing more because the time that you are doing it is a lot more intense. If you're simulating a client interview, it's not just, oh, okay, I've done my 5 minutes of this, I can drop into that. So I think when you're actually preparing for the exams themselves, it does take up slightly more time in that regard.
Yeah,
the content, as you say, it's not that the content changes. It's the same content that you've done. And I think if there is a large gap between, when you're sitting your SQE1, SQE2, making sure that you're just staying on top of that content, because then it means that it's less of a, mad rush to try and recall everything. And I think the main difference as well between SQE1 and SQE2 in terms of prep is that with SQE1, if you're slightly unsure, some people will be quite assured by the fact that a question might tick something in your brain where you think, oh, actually, I remember that. Whereas some people find it quite difficult with oral exams, the written exams, because there's nothing in there to prompt you.
Yeah.
It's, how do you apply to set aside default judgment? And you just have to be able to recall that. So I think sometimes for people, that's quite difficult. So that's why I think it's really important to do those practice simulations of the actual
100%.
tests.
Yeah, brilliant. I was going to ask as well, how prepared did you feel from the preparation course? Did you feel that you had practiced, everything that you needed to then?
Yeah, again, I think because of the way that the course is structured, and as I said earlier, all those tips about how to set out your arguments and where you'll get these extra marks, plus then having a bit of experience in practice. But that's not to say that if you haven't had experience in practice that you won't have those skills, because funny enough, we were talking about this earlier, if you've been in any kind of professional environment, if you've ever had to write a professional email, which most people have done, it might not be necessarily in work, then you've already got those skills.
Yeah, no, I agree.
Yeah, and you've both sort of mentioned about like the content of law. There was a few questions that we'd had through about what sort of depth of SQE1 knowledge did you feel was tested? How much of that did you need to have retained, really?
I would say quite a lot of it. I would say the majority of it, but then it's, as I said, it's the way that it's applied. I think obviously because if you've, I don't know, your legal writing, yes, you need to be able to recall some of the knowledge and transfer that into the assessment. But as we were saying before, because there is that skills element, it's sort of like a balancing act, isn't it?
Yeah.
So you need to be able to have that knowledge because you don't know what's going to come up in the exams, but you can balance that in the assessment. So say if there are areas where you're not sure, just include appropriate provisions for that. And I'm not saying that you're going to pass if you don't remember the legal knowledge just because you know how to write a professional email, but I think it's slightly reassuring to know that you can boost your marks in that regard.
Definitely. And I think it's also having that confidence that if you're at the stage of SQE2 because you passed SQE1, your knowledge is there. Otherwise, you wouldn't have been able to pass SQE1. So it's just remembering that. I think it's so easy to always think about what you don't know. You know, the course is really dense. There's a lot of content, a lot of areas you're questioned on, but you had all that knowledge to pass SQE1, so there's no reason why you don't have it now to pass SQE2.
Yeah.
And it's just about having that. And again, it really helps that there are 16 exams, because you can afford to not do as great in a few. But as I've said, if you've gotten to that point where you're sitting SQE2, there's going to be plenty of information and knowledge that you can showcase as well. So, you know, if you have a bad exam because you think, oh gosh, I didn't know enough of the law on that point, you know, odds are that you're going to know plenty plus in another exam.
Yeah.
So again, it's just about not being too hard on yourselves and not being bogged down by the amount you don't know.
Yeah, I think that's what you were saying. It's because I think quite a lot of people, and I didn't really realise this until I was doing the exams and I properly looked into how they're marked, is that obviously you've got the 16 exams. You could do a lot worse in, say, 2 of them, but excel in others because it's an average. So even if you come out of one and think, oh gosh, that was awful. You know, I came out of one of them and was like, not really sure I did in that one. But you know, if you then excel in other ones, your average, it sort of levels itself out. So I think it's, you know, taking each exam as it comes, and once you've finished one of the exams, just, it's really hard not to, because everyone's human, we all do it. Just trying not to dwell on it, because we've got the new SQE people that are sitting exams next month, and I was saying to them, you know, as humans, you're naturally going to like focus on the negative points, like the parts where you're like, oh well, I could have done this and I could have done that, but you're not going to remember the umpteen questions that you excelled in. That's just human nature. So I think it's really hard to say, but just try and like focus on what's coming forward rather than focus on where you could have improved, because it's out of your control at that point as well. You can't do anything. So it's just being positive, isn't it?
Yeah.
Yeah, that's great advice. And I know we'd had some questions through about the sort of legal knowledge, particularly for those that actually have an SQE1 exemption. We've had a few inquiries recently from people that have actually done LPC. But I mean, I think probably like you've said, Sophie, in terms of you've be confident that you've passed, although they haven't done SQE1, they've passed an equivalent of it. You know, the SRA is seeing that as an equivalent, aren't they? So they should really have that kind of level of knowledge.
Definitely. And you know, there's so many different routes into law now. I mean, I know Courtney did straight law at uni. I did a different undergraduate, and then I did a law conversion. So, you know, already when I started studying the SQE, I was like, oh gosh, I don't have the same knowledge as someone who's done law for 3 years. But you know, there are so many different routes now. And again, with the exemptions, the SRA wouldn't be allowing you to get to that point, as you say, if you didn't have the knowledge and the ability to be there. So again, just not being bogged down by that and actually flipping it on its head and seeing it as a positive, that, you know, okay, I didn't have to say SQE1, but I've still sat enough and I've got enough for the SRA to say that I'm ready to sit SQE2.
Yeah.
So on that, I think the only thing to flag as well is obviously you've got that knowledge, but I think the difference between the LPC and the SQE in terms of the knowledge that they expect you to have, because the LPC is day one as a trainee, whereas the SQE prepares you for, or like has the expectations of day one solicitor. So I don't think, like you're saying, it's not a case of you don't know enough, but I think I would definitely, if I'd done the LPC, I would still consider doing a prep course. I think just in terms of like the exams and just, you've got the knowledge. I think the LPC is really helpful in terms of, you know, speaking to other trainees at the firm, the people that did the LPC. I think in terms of like the practical skills, it is really helpful, because when you see them, when they move through their seats, they have just got that experience, haven't they? And I think there's pros and cons to both. I think the level of detail that they expect you to know within a short period for the SQE is very different to the LPC, whereas obviously traditionally people are in like a university or on a part-time basis.
Yeah, I would never recommend anyone to sit SQE 1 or 2, but probably more 2 without doing a preparation course. You know, the College of Legal Practice has already got all the modules in booklets ready for you. I don't even want to think how long it would take to go through the SRA's, you know, syllabus and pull together those notes. And again, it's just those. I mean, we do sort of commercial, so I've never been to court to address a judge, so I didn't have those practical skills that, again, the College of Legal Practice had a booklet for, so I wouldn't have really known how to refer to a judge or how to set out my argument to get those soft skill points. So yeah, a prep course, as you say, is definitely, regardless of whether you've done the LPC or not, a prep course would still be something I'd highly recommend.
Brilliant. One of the questions we had submitted was, what are the essential skills that you need to build up? I know we've kind of already spoken about the skills that are actually in the assessments, but is there anything else that you think that's worth raising on that?
I think like, as we've said before, isn't it? It's being like confident in yourself and the way you come across. I think when you, as I was saying before, when you are practicing the assessments, do it as if you are actually there, because I think, I mean, I roped my dad and my partner into doing it and was like, okay, you're going to pretend to be a client for me. And I think it's quite hard in that respect, because you have to like completely shut off that these are people you know, but doing that and just having to formally address, because I think we've spoken about this before. I think especially our generation, people that like grew up with phones and being able to text, you don't really, and you know, emails, you don't really speak to people on the phone that much anymore. I think obviously we have Teams calls, but generally a lot of people like text or email nowadays. So just having to address someone formally is something that's quite alien to a lot of people. And I think obviously the people that are coming through after us that are obviously younger, they've grown up with even more technology. So I think just simulating that environment, you know, practicing those professional skills, I think that's one of the most strange things, isn't it, that you don't normally do.
And I think the exam that's the best example for is probably your wills. Unless you've had experience in that area of law, there are very few times you've had to sit down with a client and advise on something that's a really difficult and emotional topic. And the more time you can work on just thinking how you would, the tone you'd maybe use, what word you'd maybe use at the start of the meeting to make them feel comfortable, and how you show empathy whilst also remaining professional, I think is really important for wills, because as you said, it's, let alone addressing clients in person, is quite alien to us. So is, if you haven't had experience in that area, speaking about things like a will. I think for each of the topics as well, like the skills change quite a lot. I think property tends to be quite technical. So especially for the sort of forms, and I mean this is with all of them, make sure you understand, again, these are on the College of Legal Practice website, make sure you've practiced the different forms, because again, there are such easy marks. If you're looking at a transfer, for example, knowing where to put who's selling the property and who's buying the property, again, easy marks, so practice those forms. I think business as well, if you get sort of the case and matter analysis, business is really good because you can think quite, you can come up with different ideas, and that's more of like abstract thinking. So I think if you're looking at the skills you need, maybe even if you just sort of Google, what skills does a property solicitor need? What skills does a wills and probate solicitor need? And from that, you can sort of kind of see the skills that you'd then want to showcase in those little exams.
Yeah, I think the same. I think it's just, as you say, each exam brings with it different challenges in terms of the skills you need. I think it is just, as you say, just balancing that so that you know which skills are required from each one. So as you say, with your drafting, it's just like, I think attention to detail in the drafting one is so key.
100%.
And I think that's, to an extent, that is the same with all others. So, when you're doing your legal research, you're given loads of different attachments to review. And it's not like, it's obviously hard in the exam because you're a bit stressed, probably, trying to rush through because you're aware of the time constraints. And I think it's making sure that you properly analyse. I think analytical skills are really, really key to, there's a lot of information that you need to review, hone in on the specific details and know how to apply those. I think being able to analyse large volumes of text and then put those forward in, a client-friendly or a succinct way is I'd say quite a fundamental skill with the written exams.
Yeah, that's a really important skill that carries across all of them. And to be honest, even oral as well.
Yeah.
I mean, I know we've said if you're not quite sure on one point, you can try and showcase the information you have elsewhere, but try and get the information across as clearly as possible, especially in the client interviews. You know, for me, I had two different sort of assessors. One was giving me loads of information and the other was hardly giving me any. So again, it's trying to gauge that client, and often the easiest way of doing that is to just speak quite simply and quite methodologically, in terms of you just take them through the steps. And although you might have all this information that you want to showcase, it's actually about taking a step back and thinking, what do I actually need to say right now, and what can I follow up in my attendance note? Because again, so for the client interview, you get your marks from the assessment, but then you also get them from the attendance note, and that can be a place there where you can showcase a bit more of your knowledge. Or if anything, it's great because if you think about something in between the interview and the attendance note, or you want to correct it, that's a really good point. You're sort of allowed to do that. So if you've given something that you later think, oh gosh, that wasn't quite right, or this is what it actually is, you just write in your attendance note, I suggested this, but on reflection, it would be better to advise the client this, and I'll follow up with an email.
Yeah, I was going to say, it's making sure, isn't it, that you flag that you've told them one thing that you want to correct the other, isn't it? Don't just say, this is what I've told them, because obviously that's not the case. So it's that discrepancy, isn't it? But yeah, as you say, you get that opportunity to expand a bit more, and I think it's focusing on what the client needs. As you go through the interview, the client will tell you more things, and I think you might have a set plan of what you want to address in the interview, but listen to what the client says. I think that's the other thing, isn't it? Like, leading on from what you were saying, like, don't just stick to your plan. If it gets hijacked by a client saying something, go on that, because that happens in day-to-day practice all the time, in terms of people, you know, you think a meeting's going to go one way, and then 5 minutes in it goes a completely different direction. It's just being prepared for that, and, you know, being able to maintain professionalism when that does happen.
Yeah, there's a question has come in actually, specifically around the oral exam, so we'll pick that one up now. Will the assessors sort of prompt you in any way if you fall short on the knowledge, or were any of the oral assessors ever a bit difficult? For example, a difficult client or a harsh judge?
I don't think any of them were difficult. I think so in terms of, so for example, in your wills, obviously, I don't know, say if you're trying to calculate the value of someone's estate, there'll be, you know, in the College of Legal Practice, they'll set out points that you're meant to ask to, you know, ascertain the value of the estate, see whether it falls under inheritance tax. And I remember in mine, I queried, you know, whether the client had any assets, and they were like, what's an asset? And in your head, you're like, are you just being difficult? But I think it's a way of them prompting you, like you say, to, you know, it wasn't necessarily falling back on the knowledge, because they're not legal professionals, they're not legally trained, they're actors in the client interview. But I think it's that, you know, it makes you think, okay, so things like bank accounts, things like that, and then it gives you the opportunity to expand on that. Whereas if you just ask someone assets, they might have been like, no, I don't have any assets. So it like probes, you know, you have to probe a bit more, which is a skill that, you know, it doesn't necessarily mean that they're difficult, because some clients are like that in practice, aren't they? And I think it's just your skill of being able to, you know, probe a bit deeper.
Yeah, I had a sort of similar experience in my dispute resolution advocacy. It was a test that I didn't know as much on, and she must have picked up on that. And at the end of the exam, she asked me to confirm, like, set out the test clearly, and I had to say, you know, sorry, Judge, I can't do that at this time. You know, I can come back to you on that point. So they can see maybe where you might not be able to exactly answer, and they might ask you a question on that. But again, they're judging how you respond to that.
Yeah, I think they're giving you the opportunity, aren't they? They don't want you to fail. They're trying to give you the opportunity to expand it if they think, oh, maybe that should have been addressed.
If anything, it is an opportunity. But it's an opportunity both ways, because it's an opportunity if you know it and you can give the answer, but it's also an opportunity for you to show your ethics if you don't know the answer, to be able to put your hands up and say, I don't know that, but to do it in a professional way that, you know, I will come back to you on that, things like that. So again, the oral exams are so hard, and there's so many things you can possibly worry about. But from my experience and for the people I spoke to, the assessors were trying to get the best out of you, whether that was by coming across, as you say, what you might think is difficult, but they're not. They're giving you an opportunity. Or even if, you know, you're in the client interview, maybe they're giving you too much. Because I spoke to someone and they said, gosh, my client, my assessor just didn't stop. But that again gives you another opportunity to showcase a skill, because it's how you navigate that. You say, right, okay, appreciate all those things and we'll come back to them, but, you know, just bringing you back to the points that we're here for today. So try not to see it, again, we're just trying to say flip everything on its head, but I think that's the best thing you could do in these exams, because they are grueling, they are really challenging. So anytime there's something that, right, this seems difficult, try and see how there could be actually a benefit in it, because I think that's what keeps you going.
Yeah, brilliant. Thank you. There's a question about hard copy materials and do they mirror what you get online. So you get a hard copy skills manual, don't you? But obviously a lot of the you can access the skills manual digitally as well, but a lot of the interactive activities and things are online for you to do then as well. There's lots of questions that came through previously as well, just about, as always, I think with SQE1 as well, but how do you manage your time, you know, whilst working as well, whilst trying to have possibly a life at the same time? You know, how did you manage it?
Yeah, do you want to?
We probably managed it in quite different ways. Very, very, very organised, and I wish I was as organised. But I think, looking back, the best thing you can do is make a timetable at the beginning and make it realistic. Don't say that you're going to cover weeks 1 to 10 within 4 days, because that's just not possible. Realistically, again, looking at, you know, if you've got any events coming up, if you've got a busy period, if you know you've got some caring responsibilities, you know, build your calendar around that, and check in and do the practice test, because it's so much help then when you get to really knuckling down to revise. You've already done the soft skills preparation, so you know how to sort of set out a letter, you know how to do the advocacy, so then you can really start revising the content and really going through it. The other thing I say to everyone is, if you have fallen behind, it's okay. Don't just sit there and panic, reach out. You've got people at the college, you have your you know, people who monitor you as you go through, and if they reach out and say, is everything okay, I've noticed you've fallen behind, etc. If there is something, flag it, because there might be something the college can do, there might be something the SRA can do, you know. So don't just sit there and panic more and drown. And if you are at this situation where you've fallen a bit behind, I always say to people, you know, it's better for you to put your eggs in lots of baskets than just one. So don't just sit there and maybe finish business, but then you've touched none of dispute resolution. Try and go through them both as far as you can. And even if you don't know a bit of both, it's better to know some of both than all of one and nothing of the other.
Yeah, no, I completely agree with that in terms of things, but especially the timetable.
Yeah.
I think because as you say, time management, you need to be able to balance. I mean, you need to be able to still have a bit of a life during these exams, otherwise you're just going to completely burn yourself out. And I think there's only so much your brain can actually retain. I think you need to make sure that you have breaks. It's so easy to think, gosh, I've got all of this content to get through, I don't have loads of time, I'm just going to absolutely cram everything. And it's like, that's your brain is just not going to retain that. You might have, you know, short-term recall, but you need to be able to take that time to process it. So I think, like Sophie was saying, it's just mapping out when you have your like non-negotiables. So like for me, I was like, I really want to make sure that I'm maintaining, you know, netball and exercise. So I was like, how can I make sure that I can still do that, not feel like guilty for it, in terms of, because I think it's quite hard, isn't it? Sometimes you think, I should be revising whilst I'm doing this, but you know, having those non-negotiables. And then there might be some things where you think, okay, they are important, but in the grand scheme of things, say you're like a few weeks out from your exams, could they, are they non-negotiables? And I think for everybody that's different. Like you say, some people might have caring responsibilities, so those, you know, they're not non-negotiables, they're things that they need to do. And I think it's just being like supportive to yourself in terms of recognizing when you can and can't give your time. And I think especially for people that work full time, that's even more so important, because you're balancing work and you're balancing extra commitments outside of work. So yeah, I think in terms of just making sure that you stick to a plan as best as you can, but as Sophie says, like don't focus all on one of the practice areas, because it's better to know a bit of everything. I think there's so much content as well. Feasibly, you're not going to be able to recall every single part of every practice area. So making sure you've got a good knowledge basis for all of the practice areas, that's the best way to put yourself in the best position going into the exams.
Yeah, and I think what I found really helpful was, so although say now you've got dispute resolution as a topic, contract and tort fall into dispute resolution. So I found it really helpful to sort of look at those groups and be revising those groups together, because when you get tested, so for example, your advocacy for dispute resolution might have like a contractual element or a tort element, and then you've also got the dispute resolution element then with the advocacy. So make sure you know what sort of goes together, and then I just find it's easier to revise those things again together, because they all build the knowledge around it. Your contract helps your tort and your tort helps your advocacy, and it's a nice circle then.
I was going to say, just in terms of like a general tip, when we were just talking now, just thinking about it, as you said, like things like this are really helpful, but if you can speak to anyone that's been through exams, I think that's so important, because you might think, oh, I don't have time to do things like that, I need to be revising. But I think just having an awareness of how the exam actually works, and what sort of like approaches that the clients and the judges, people's experience of that, I think that helps a lot, because it's just basically an unknown. I think when we did it, we were like the first ones at Acuity to do it. So you go in and you're like, oh, I have no experience, like no one's ever told me about this. Whereas now, obviously, like we're both not advocates, that's not the right word, but we're like always willing to share experiences of, because I think that's really helpful, just alleviate some of the pressure that people put on themselves of the, oh gosh, what am I walking into? So I think that does help. I try and say make time to, make sure that you're aware of the structure of the exams.
Yeah, and that you've looked into, I know the dates change, and make sure you've looked into where the test centre is and how you're going to get there, and if you're relying on public transport, might it be an idea to stay in a hotel nearby, remembering that you need 2 forms of ID, just speaking to people who have done the exams. It's small things like that you might not have thought of that could actually be really detrimental if you can't get to the exam. That's probably the most important thing. You need to be there. So
it's all those things you sort of gloss over, don't you, when your head's in the content and the skills, all these things which just will alleviate so much pressure for you, make it so much easier for you on the day.
Yeah, brilliant, thank you. Another question that's come through then, with a written exam, could you sort of explain a walkthrough of the structure and how you managed your time? What was the sort of length of time of the written exams that you had?
They differ, don't they? So some of them are half an hour, some of them are 45 minutes, and one of them's an hour, the case and match analysis. So I think I personally found that the legal research felt like it had the tightest time constraints, just because I think I had about 8 different attachments to review, and then obviously the scenario, and then you've got to set out your research and your references at the bottom, and don't forget to do your references. But I think in terms of that, it's very easy. So if I take the legal research one, it's very easy to see, okay, I've got all of this information. As I was saying before, you might gloss over things because you're trying to read through everything so quickly to make sure that you can then start writing the actual research that you've conducted. I think it's making sure, I don't know, say if it's 45 minutes, give yourself like a good, 20 minutes just to properly review all of the attachments to make sure you don't miss anything. And you get it's like a whiteboard sheet, isn't it, that you can write on. So I just wrote like the numbers of the attachments, and then if I'd gone through one and thought, that's not really relevant, I just crossed it out, so then I knew not to do it. Or if there was a specific page or a paragraph, I then added it and wrote, so that then when because it's not the easiest to click back through all of them, is it, on the screen? So it just then makes it a lot easier. So you spend that dedicated, say 20 minutes, then you've got your 25 minutes just to properly get into the research, and you're not having to flip back between things because you've not properly taken it in.
Yeah, that's really good tip. And practice legal research by doing it in that way. Like you said earlier, the importance of, I would say legal research is another one that's really important to do under the time constraint that you're given in the exam, because you won't believe how quickly time goes when you're reading through. and you think, oh gosh, I've not got long to even write what I need to anymore. I think for legal drafting, the best thing you can do is go through every single example on the College of Legal Practice website and make sure you understand those forms and can just sort of regurgitate them basically. Every single, and I can't say that this would always be the case, but every single form I had in the exam I had already seen before. So that's really helpful. But again, don't panic if you haven't, because often with legal forms, they have guidance throughout it. For example, I said earlier about a property form, like one of the things you have to fill out is property, but you'll have the address of the property, so you've already got that. So if you haven't seen the form, don't panic. Look at it as you will be this is a form I've seen for the first time, I'll just take it face value, because a lot of legal forms are designed to be accessible. For the case and matter analysis, this is probably where I think you've got a bit of opportunity to showcase your knowledge and showcase the way you think. And again, setting it out clearly. The way I went about that was looking at so I'm not sure if this works for everyone. I went straight to the question, what am I actually looking for? And then when I went to review all the information about the case, I sort of already knew what I was kind of building towards.
So you're not just reviewing everything.
I'm not just reviewing everything and getting bogged down. Yeah, it's focused analysis. So I think that helps for case and matter.
Yeah. And then I guess with your legal writing, it's because that's got the shortest time.
Yeah.
I think it's half an hour. So I think it's just, as we were saying before, you've got your skills. So literally at the beginning, just put dear the person it's to, and then whatever the appropriate address of who it's from, so yours sincerely, yours faithfully. They're like 2 easy marks that you've got, and then like a subject line. It gives you then some structure, and you could even like square bracket it if you're the type of person that needs. You forget the structure. Just do that at the beginning. And then you don't have to worry about the end of, oh, I forgot to sign off, or at the end, should you have any questions, please let me know. I'm more than happy to discuss things like that. Are just easy marks because that's what you would do in practice. And they're things where, because it's such a time pressured exam, I think that one is the one. It feels like you're constantly typing from the get-go.
That
just gives you the extra marks, doesn't it?
Yeah, and just make sure you're really reading what the question's asking for you in legal writing, because there will often be a question sort of thrown in there, because it'll be like a partner's emailed you to do something, and then at the very end it might say something like, oh, and the client just had one quick query as whether they could sign it like this. And if you weren't paying attention, you'd probably miss that was that question. So as you said with the research, don't be afraid to take time to read and digest, because that makes the time you have for typing actually really effective time. Whereas if you're just typing without really digesting the content and what the question's asking from you, you're probably going to get bogged down.
Yeah, and I think there's nothing worse as well than then getting to near the end of the time and thinking, oh, and then you see that extra bit and you think, oh gosh, I've come, and then it might throw off your structure. It just, and I think, on a separate note, I think with the written ones, you do 2 and then you have like a short break. Is it before you click to the next one?
Yeah.
It says, oh, do you want to proceed? I think after you've done that first exam, so say it's legal research, before you click next, just have a minute to breathe. I think that's so important, because 100%. Especially if it's not gone particularly well, you don't want to go then into something that's got a time pressure. And you're still thinking, oh gosh, I should have said this in the last one, I should have done this. Just take that time to breathe. I mean, obviously don't sit there for ages, but just take that time just to reset and think, okay, new exam, it's an average across all of them. Let's just go at it with the most positive approach that you can. I think that's sensible, just to take that time.
Yeah, just to touch on that, all of them, the orals and the written exams, you'll have 2 and then a break, and then the other 2. So as you said, you've got that big break where you have a real chance to breathe, but you'll have a little break in between the 2.
Just like click through,
and just take it. Just even if it's just a few.
Just to breathe.
In and out breaths.
Brilliant. And then just sort of nearly wrapping up, but there was another question that came through as well, is did you sort of get a guide on what examiners are actually looking for, such as a basic way to demonstrate a particular thing, you would need to do this, but then to get like extra marks, you would also need to go into XYZ?
Yeah, so again, I got this from the College of Legal Practice material. Once you do the sort of practice, you have the sort of mark scheme to go off. And then what's often really helpful is that even if they're on different topics, you'll be picking up running themes. So for example, wills can be on anything from week 1 to 10. But if in your first practice you didn't sort of, when the client first came in, you sort of said, oh, no, I'm sorry for your loss. I appreciate this is difficult and we're here to support you through this. That carries throughout most of them, because it will be often a client who's recently lost someone who's coming in to speak to you. So even if the content is different, you'll pick up so many skills from doing as many of the practices as possible.
Yeah, and I think as well, I know on the SRA website, it does sort of explain like the breakdown of the grades and the specification. I think it'd just be a good idea to read through that, because you get marked A to F. So A equates, I think it's 5 marks, and then it drops down to like an F is 0. So I would recommend looking at the way that they mark it, because it is quite complicated. I think the way that they look at the different skills and they break it up, and then there's all these letters. I think it's useful to look at that, because that does give a really useful breakdown of what they're looking for. It might not give the exact detail of, you need to, as I think you said in the example, like show empathy. I don't think that's particularly there, but it might be like your ability to convey professionalism or something like that, and that falls within there. So I think that's a really good thing to consider as well, because I remember the marking scheme being very different, obviously, to SQE1 as well.
Yeah, no, it is quite difficult to look through the mark scheme and sort of get your head around it. But the other thing, when you're looking at the mark scheme, you have to remember it's a first day qualified solicitor, where it says like the person was competent or above competency. Like that doesn't mean that they know everything about the law and they're like at senior partner level. You don't know everything on your first day of qualification. It's just at that standard. Are they competent?
Yeah, that's brilliant. Thank you so much, both of you. I think that's been really well appreciated by attendees tonight. I've just been able to hear you just talk about it, because I think we always focus so much on multiple choice questions for SQE1 and things, and there's just so much detail, I think, to SQE2, and so much that it's hard to appreciate what is involved without hearing you explain it further. So thank you both for joining. Thanks everyone that's joined us this evening as well. I will email a copy of the slides and recording over as well. And then obviously any further questions, I can help you after that as well.
Yeah, just on that as well.
Reach out
to us.
Yeah.
We say it to people all the time, and it's actually not just a polite thing we do. We want you guys to sort of reach out. We're here to help. Yeah, it's difficult and it's challenging, and you're not in that alone. People have gone through it. People are going through it. People fail. I know that's a word people don't like to hear, but people fail and still go on to becoming really successful solicitors. So always reach out to people, and just that first-hand experience, we're here to we're here to relay that to you, and we'll be honest about it as well and transparent. So please do feel free to reach out to us.
Yeah, no, I echo that.
Oh, brilliant. Thanks very much. Have a good evening, everyone.
No worries.
Bye.
Take care. Bye.